party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. And just please let me know because I'm trying to keep the time, and I'll let you know when you're entering into the rebuttal time. Also, this is not really, again, relevant to this case, but we always make sure we indicate that please do not mention the names of any victims and or children. We are recording, as we just discussed, and it is being videotaped and will be aired on, available on YouTube channel. So, so keep your voices up. Again, that's no problem for the appellant's counsel to sit at the table. We will have the camera is positioned so that it will get you on the recording. It's just a matter of we just want to make sure that everybody's in a place where we can get them recorded in their voices and so forth. Their being, their physical being, and their voices. So, at any rate, all right, we are ready to proceed when you both are.
Thank you, Your Honor. My name is Attorney Robert J. Gargas, and I'm here for the appellant Mark Campolo, Mark A. Campolo. And I guess I would like to take the opportunity to let you know that Mark is a retired maintenance gentleman who's worked all of his life very hard, and he was able to save up some money that he had hoped that he would use for his boy's education. And it is that $85,000 that has been stolen from him, okay, as we alleged by this defendant, the appellee. Now, Mr. Protelsky and his companies, he is a relative of Mark's. So Mark had his guard down, okay? Mark believed that this man who had made independent investments was going to help him build the wealth that he needed in order to put his kids through school. So he probably didn't, have all of the safeguards that maybe we all would have to protect our wealth, because this was a relative of his. Now, what we have in this case, Your Honors, is, the judge, I believe, is an abuse of her discretion in throwing this case out, saying, well, we didn't comply with discovery. But I have to ask you, how is it that we didn't comply with discovery? We provided initial discovery, the book of evidence that's been recorded that was attached to Mr. Campolo's affidavit. We prosecuted this case very diligently. We went and tried to obtain summary judgment. We defended against summary judgment. The trial court found that there should be a trial on the matter. The investigation by the state of Ohio Division of Securities wasn't even completed in final form until just before my appellant's reply brief was filed, and I put it in as Exhibit C so that you could see there was an ongoing investigation. This original investigator from the Ohio Division of Securities was a gentleman by the name of Mr. Brown. Mr. Brown had this case for a number of months, and when it got to the expiration of the 2-year statute of limitations that Mr. Campolo was up against, we just simply couldn't wait anymore. We were calling and trying to stimulate activity on behalf of the state investigators. The state then switched investigators to a new investigator, and so we had to file the lawsuit, which we did. And it was like maybe a month just before the expiration of the 2-year statute of limitations.
Counsel, let me interrupt you because
Sure.
One of the points that the appellee is making, that what you're saying is not in the record. In other words, they've indicated there's no evidence in the record that there were even any investigations pending. What do you say to that?
I believe that it's been determined in Mr. Campolo's affidavit that he was working with not only the state investigator, but also with the county prosecutor's investigators. I believe that it was no secret, and even today, the matter is still not completely resolved in the criminal investigation. We've got Sheriff's Deputy Scharschmidt, who's been talking within the last 2 weeks. I got an email from.
Well, we can't consider that. Because it's not in the record.
I understand it, Your Honor, but the reason I raised this is because the court threw out my client's case, saying that he wasn't prosecuting the case, saying that there is nothing of investigatory nature. But even Judge Morali, retired, had requested that there be some investigation be made. Now,
Well, counsel, as long as we're talking about the record, did the trial court have an oral hearing regarding this discovery matter?
I do not believe it had an oral hearing. I think there was just discovery. I filed a motion to extend discovery, and it was opposed, and then there was a motion to dismiss, I believe, for failure to prosecute. And what I think irritated my opposing counsel was the fact that Mr. Campolo went to a wedding reception, and at that wedding reception, just before the third $35,000 crypto investment was made, Mr. Przytulaki came up to Mr. Campolo at that wedding, and it's in the affidavit, and he asked him about had that gone through. Well, if he didn't do it, then why would he be talking to Mr. Campolo about whether or not the third investment for $35,000 went through? And I have been trying to get, he was there. He lied. I shouldn't say he lied. He perjured himself in a deposition that I took. He said, I never went to a wedding reception. I haven't seen Mark in years. Well, that's just not true. And I told my client, I said, hey, you got to go get evidence of this stuff. So the father of the bride is called, and the father of the bride says, yeah, Mr. Przytulaki was there.
And remind me again how this is all in the evidence, how in the record.
It's in the affidavit of Mr. Campolo. And as soon as we had it, we wanted to make sure it got out to the investigators.
Was the...
And I didn't hold it back, I gave it to Chris.
Was there a affidavit that was presented by the father of the bride?
No, just Mr. Campolo's affidavit, and referencing the admissions or declarations and visions of not only the father of the bride, but there were other people there that recognized him there as well, including Mr. Campolo's son, who was at the beginning of the ceremony reception and observed Mr. Przytulaki there. I don't think there was any type of dispute other than the fact that he denied it. Well, why would you deny it if you were there? I mean, you deny it, why? Because you don't want to be there? He was there. He asked Campolo about it. Now, what's interesting, Judge, is Mr. Campolo, he doesn't know how to do any of this crypto stuff. So this book of evidence, he screenshot every document that was transmitted in order to have these investments made. And it's all compiled and has been presented as evidence and was discussed page by page in the deposition and is set forth, in the explanation of Mr. Campolo as to how he got duped and how exactly what he did in order to have this money transferred, wire transferred from his bank to the location of where he was told it needed to go. So I asked this court to recognize that he's a victim of a crime.
Counsel, I want to ask you about that, because you say that in here, Mr. Campolo being a victim of a crime. So has there been some determination to that effect that somebody has engaged in criminal conduct against him?
I believe the Ohio Division of Securities has found that the felonies...
Is this in the record?
Yes, it should be.
Okay.
Absolutely, Your Honor. And I have to tell you that the indictment isn't here yet, but it's being investigated for an indictment.
Counsel, you mentioned the Ohio Division of Securities, but they found that Appley's name was misappropriated.
Well, did they? Because they didn't get the what do you call that? The ping test. One of the things that's under investigation, if Mr. Przytulaki was at the wedding reception, did his cell phone gave off signals, right? He can't say his cell phone isn't there. That's still under development. That evidence is still under development.
Well, but the whole point is, my understanding is that there was the transcript of the investigatory hearing that was conducted by the Ohio Division of Securities, and they had said that his name was misappropriated.
It's claimed it was misappropriated.
His name
but,
was
but
misappropriated.
how would his name be misappropriated if the telephone
Well, I don't,
ping would show that he's at the wedding reception?
well, I'm not,
I'm just trying to say, Your Honor, I'm trying to nail it down.
I understand, but what I'm saying is I'm just looking at what is in the evidence in the record. And what the trial court said here was that you had not turned over the requisite discovery request, the information, and she had given you several times and you didn't do it.
Well, but what discovery? I can't turn over that which I do not have, that which I am working on, that which I am trying to get the investigators to look at, spend money on. I can't turn over anything but what I have, and everything that my client had, we turned over. And that's what I'm trying to understand is, I wasn't playing games as somehow it was reflected by the trial court. And by the way, doesn't the Ohio Constitution give victims some rights to be able to sue the people that rip them off? I mean,
Counsel, you are starting into your rebuttal time if you want to save it or continue. It's up to you.
Yes, I'd like to hold it for my rebuttal, Your Honor.
Thank you. You may proceed when you're ready. You have 15 minutes.
May it please the court, good morning. Christopher Mulvaney, counsel for Appellee, Jeffrey Podolsky, and his trust. Just in the interest of clarity, I do not represent Prime Asset Equity or any of the other potential parties in this case. As a preliminary matter, say that my client denies any involvement with any money that is at play here, and denies communicating with Mr. Campolo regarding this matter, period. I would say we do agree an investigation was conducted by the Ohio Division of Securities. My client cooperated fully in the investigation, sat for an interview, provided documents, and we have not heard anything subsequent to that. There were references made in various briefings by Mr. Campolo regarding investigations by the Ohio Sheriff's Department, the Lorain County Sheriff's Department, or other law enforcement agencies. That is what we have no evidence in the record that they've ever begun. There's reference made to a statement by Judge Moraldi prior to his retirement, referring this for investigation. Unless there was a conversation I was not a part of, my recollection of that case management conference, again, it's not in the record, was that he expressly said he did not have the authority to refer it for any investigation.
Counsel, was there an oral hearing with respect to the discovery?
No, there was not a formal oral hearing regarding the discovery. It was discussed at multiple case management conferences.
Off the record?
Off the record, yes. So it was discussed extensively leading up to the February 4th judgment entry, and again on March 18th. Prior to the entry dismissing the case, we discussed the issues of discovery extensively. We also discussed discovery in the October case management conference where plaintiff, Mr. Campolo, stated he needed until December 3rd to provide the responsive documents and responses to the interrogatories.
And again, none of that is in the record either.
That the court extended the time until December is...
Right, but I mean, the conversations were all off the record.
Correct. The conversations were off the record. I can say that my client did fully comply with all plaintiff's discovery requests, turned over all documents that were requested, answered all interrogatories, and sat for the deposition. We have not received any notice from Mr. Campolo that they believe any of the responses were deficient.
But the real issue we're here, the main issue we're here for today is not whether there was wrongdoing or there wasn't any wrongdoing. The issue is, did the trial court, I should say, abuse its discretion in dismissing the appellant's complaint on the basis of a discovery sanction? And you would agree that's very unusual.
I would definitely agree that is highly unusual. I think this is the first time I've seen it in my career based off of a discovery sanction. But I do think that the trial court's decision was proper. It was not an abuse of discretion, which I do agree is the appropriate standard. And I believe the decision does follow the precedent outlined in Quonset and Russo v. Goodyear Tire and Rubber, which was affirmed by Pietrangelo versus Avon Lake.
Well, counsel, there is a reference in your brief about Mr. Campolo purposely withholding.
Correct.
Okay. Is there anything that you can point to in the record that would show that?
So what occurred was at the March 18th case management conference, there was a discussion about the status of discovery.
And that was off the record?
That was off the record. Counsel stated he was holding recordings that were responsive to the case and was intentionally not turning them over so he could hope to ambush my client with them at trial. If you look at the supplement.
Counsel, but that statement, we're not going to find that in the record anywhere.
That is correct. I would note in the supplement to the motion to dismiss that was filed, I believe on March 20th, references an email that I sent to Attorney Gargas following that case management conference where I stated, this was my understanding of what you said. Please advise me if this is incorrect.
And that's the trial court record, that email?
Yes, that was attached to the supplement to the motion to dismiss.
Thank you.
And I would say that no response has ever been received indicating that counsel believes that statement is incorrect or inaccurate. I think that prior to the dismissal of any case regarding discovery sanctions, the courts have set forth some clear guidelines. The Quonset v. Ford from the Nevada Supreme Court requires that a party be put on notice that failure to comply may result in the dismissal of claims. And specifically that they need to be given an opportunity to explain the default or correct it, or to explain why the case should not be dismissed with prejudice. In the February 4th, 2025 judgment entry by the trial court, Mr. Campolo was specifically warned that if he failed to comply, sanctions would be imposed up to or including dismissal of the action.
Usually, though, the case law provides, and based on the rule, that that's a last resort, and it's more usually a progressive type sanction. Nothing was done here. I mean, I understand there was a motion to compel granted, things like that, but it wasn't like the attorney was fined or was said that, the information won't be available at trial, any of those type things that is the more usual course of action in regard to discovery violations.
I understand, Your Honor. The position would be that given the length that the case had been proceeding, we were 20 months into the case, discovery had been outstanding for 8 months at the time it was dismissed, and we simply had not gotten the information we required in order to mount any sort of effective defense of this case.
But in regard to that, okay, so it's been 20 months. The court could at any time have sanctioned him in a less restrictive, less, obviously imposing manner than dismissing a case.
I think the court had the option to do so and would have been able to consider it, but I think it was the trial court's discretion as what sanctions to impose on the plaintiff. And again, I think it was fully within the bounds of the trial court's discretion to dismiss the case. I don't know, we have not even had the opportunity to take Mr. Campolo's deposition in this case because we haven't been able to receive necessary documents. For example, Mr. Campolo has claimed that he's turned over everything he has, that he's given us everything he can. Well, in the book of evidence that was referenced earlier, Mr. Campolo was exchanging communications with somebody impersonating my client. And in that, he's asked, have you ever been involved with crypto before? And I'm paraphrasing here, but his response was, some Chinese woman talked to me about it, but I didn't do it because I didn't know who she was. One of the things that we asked for in discovery was his Facebook communications, or whatever platform he was using, with this Chinese woman he referenced. Because it is our theory of the case, and this isn't necessarily the record, that that was the same person who ended up impersonating my client and potentially defrauding Mr. Campolo. But I want to be able to see what was said. We believe that a large portion of the communications identified in that book, which referenced things which are going on in Mr. Campolo's life, was information that could be gleaned from a review of Mr. Campolo's Facebook and other social media postings, which is why we asked him to provide copies of his social media postings from the times relevant to this complaint. He refused to do that. And it's obvious that Mr. Campolo had the ability to take, at the minimum, screenshots and produce the screenshots, because that's what comprised his book of evidence. All of these things should have been able to be accomplished with screenshots.
What was the reply, that it doesn't exist, or?
No reply whatsoever. There was no objection to any of the requests for production. There were no statements that things were deleted, no statements that he doesn't know how to get it. There was simply no response. And if he'd at least said, we don't know how to produce it, then we could have discussed and potentially tried to find a third-party expert. But with simply zero response whatsoever, we can't really do a whole lot. For instance, we also asked for his IP address for his Mr. Campolo's electronic devices. We asked for usernames, identifying account information for his social media profiles and accounts, because we wanted to be able to subpoena those in order to get full copies of the records. If we were able to subpoena those, we could look to, for example, check the IP addresses of the people he was communicating with. Without the identifying account information, we can't subpoena those records. So without the ability to get any of the information that's required to defend the case, information that is within Mr. Campolo's possession, for which there's been no argument made he lacked the ability, either technical or otherwise, to produce. In fact, we know he has the ability to produce some of it, but he did not, and provided no explanation whatsoever for why he did not produce it. I think that Russo v. Goodyear identifies a series of factors that the court should look at in terms of a dismissal with prejudice for discovery sanctions. Identifies a number of opportunities and amount of time to comply that was provided. I would say the defendant, Mr. Campolo, had multiple opportunities to respond and give some explanation for what is happening with these documents. The first opportunity was his initial time to respond. Then it was extended till December. So the initial time to respond would have been ended in late September. We had a case management conference to discuss discovery. It was extended until December. No response was received. That's when the motions to compel were filed. Again, there was no argument by Mr. Campolo that he was unable to produce any of these documents. The sole explanation for what Mr. Campolo needed in order to provide that response was an expert witness. We still don't have an expert witness. Nobody's been identified. No timelines have been provided for when the report will be provided. All he's ever said is he needed time to get an expert witness. There's no explanation which has been provided whatsoever with regard to the failure to provide the rest of the information that was requested. Again, Russo also identifies, in fact, of what efforts, if any, were made by the defaulting party to comply. And as far as we can tell, there were little to no efforts to comply. If I'd gotten responses back which said we object, we don't have it, documents are missing, they were deleted. I've had multiple clients, much to my chagrin, who routinely delete all of their text messages and emails. If he had responded and said, we deleted the messages with the Chinese woman because they were clogging up my inbox, I wouldn't be happy about it, but it's an answer. It gives us something to work with.
Counsel, you're down to less than a minute.
Thank you. Ultimately, I think this case really falls in the Russo guidelines. Mr. Campolo brought the action, and as far as we can tell, spent 20 months and took virtually no effort to gather any new information, subpoena any records from anybody. Even after the preliminary report from the Division of Securities was released, identifying multiple individuals, both in the United States and abroad, who appeared to have direct relationship with this, even though he was received permission to amend to add additional parties. No effort's been made to add them, to subpoena any records from them or from any of the banks or institutions. Ultimately, my client simply cannot defend himself and defend this case unless Mr. Campolo provided these documents, and his failure to do so
And you're out of
proper
time.
dismissal. Thank you, Your Honor.
You have 4 minutes and 51 seconds left.
All right, thank you, Your Honor. Your Honor, I don't know what he's talking about. He never asked to take Mr. Campolo's deposition, not one time. We would be more than happy. We volunteered all kinds of
Counsel,
information.
I believe
Judge
his
was trying to
statement was, we don't have the documents we need before, to enable us to request the deposition.
Well, that's simply not true. Before he even asked anything, I took that book of evidence over to his office and had it delivered personally to him. You know, he's had everything that we've given to an investigator. Also, you know, the Secret Service has been contacted. The FBI has been contacted. We've been trying, you know, I don't have the ability, and Mr. Campolo doesn't have the ability to run down Interpol and wire transfers overseas.
Counsel, let me ask you a question. This seems a very simple question, a request. They indicated that they asked for the IP address that your client used, which computer, the IP address, and evidently you did not respond to that.
I can't believe that. I had discovery responses that were provided to counsel.
Did you
Everything
provide, did you provide,
yeah,
counsel, did you provide the IP address?
I believe we did.
They indicated that you didn't, that you just said it was.
Yeah, I heard it, and I'm in disbelief over that. I can't believe it. You know, not
So
only
when I look at the record, I'm going to see that you provided an IP address.
if the answers to the discovery is filed, yeah, you're going to see that.
Because that doesn't have anything to do with any investigatory agencies.
Well, but it does, because they were supposed to be investigating multiple IP addresses. And they were supposed to be getting back to us and tell us where the status was. There is nothing that says that he could not have proceeded with defending his case. In fact, he never went to the Lorain Police Department. He never went to the sheriff's office that I'm aware of and said, here's my computer, look, have it forensically examined. We were willing to do that. We offered everything that we had available for inspection.
So counsel, he indicated that there were no objections to the request for production, no response whatsoever, no argument that you couldn't produce the discovery or explanation of why you did not.
We
Is that-
responded to discovery, and I never ignored anything. If I couldn't answer it, I told him it would supplement when available or something like that. But I tried to have my client answer every question in any proper discovery that was submitted to us. We held nothing back. Nothing. So, you know, we're in a situation here where this ambush thing, no, I didn't try to ambush anybody. I gave it to him. Okay, what I wanted, the ambush would have been when the investigator went to him and said, were you at this wedding? Did you speak to the father of the bride?
Counsel,
That's what
Counsel, I have to tell you, I'm getting a little annoyed with things that are not in the record being presented to us, okay? Please limit yourself to what's in the record.
Well, then I have to ask the court to examine the Campolo affidavit, which the trial court found, you know, created genuine issues of material fact and indicated a trial should be had. The gentleman, my client, Mr. Mark Campolo, had $85,000 stolen from him. He's a victim of a crime. And, you know, we've got Article 1, Section 10A in the Ohio Constitution that needs to get some deference here. You just don't throw somebody out with a res judicata argument, which is what this trial court did. If that's not an abuse of discretion, what can be relative to a discovery dispute? And there was a case that just came out a week ago that
Counsel, we can't argue something that just came out a week ago unless you supplement the record.
okay, and it just came out.
Okay,
10
well, we will be glad to look at everything. We always do. We're very thorough in our research.
And I can't file a case after the statute of limitations expires because it's under an investigation by the Ohio State Division of Securities, or because, you know, there's some type of a criminal proceeding that's ongoing. You know, if I don't get the civil case filed, we lose statute of limitations.
And you have 11 seconds left.
Dismissal with prejudice, it could have been dismissed without prejudice, and then we could have refiled it. The way this was handled, absolutely prejudicial to my client, a victim of crime. Thank you.
Thank you. Thank you both for the presentations to the court today. We will take the matter under advisement and issue a written opinion that will be sent to both sides. And we also release everything on the Supreme Court website, so that's available electronically as well.
Thank you, Your Honor.